to the Security Council, for the simple reason that the Security Council, allows the US to exercise a veto, whereas in the General Assembly, there is not, we just go by majority or, in some cases, 2/3 vote. Secondly, the General Assembly has a long history of incredible sympathy towards the decolonization movement. That is not the case with the Security Council. So I'm just sort of mentioning why it is important to remember that the US remains hegemonic, so we choose our fora in a tactically wise way. All right, let me get right away into the first possible narrative. This would be deoccupation. For each of the narrative, I will summarize the key elements, and then I will briefly tell you the pros and cons as I see them of the narrative. Okay, in a nutshell, the deoccupation narrative presents the United States as the military occupier since 1893 or 1898 of the formerly independent state of Hawaii. And by state, I don't mean US state, I mean international statehood, Hawaii. Under the 1907 Hague Convention and the Geneva Convention 4 of 1949, both of which form part of a larger body of international law known as the laws of war, a belligerent occupying state may not, while hostilities last, either annex the occupied state nor modify its laws, except as is strictly needed to assure security for both the occupying administration and the occupied population. They have administratively replaced the independent administration, so they are going to be having to make decisions. The international law recognizes that, but tasks them with disturbing the pre-existing legal structure as little as possible. All right. At bottom then, the laws of war anticipate that occupation is a short-lived phenomenon that must not be allowed to prevent the occupied state from returning to its normal status once the occupier leaves, usually pursuant to signing a peace treaty. Arguably, the US could sign such a peace treaty with duly constituted representatives of the descendants of the Hawaiian Kingdom subjects today, thereby enabling an independent Hawaiian state to reconstitute itself. That's it in a nutshell. Let me point out very quickly the pros and the cons. The pros of this model are as follows. Were international society to find this narrative persuasive, and that's the key point, is it going to be persuasive? Deoccupation likely constitutes the cleanest way back to the time before Hawaii suffered its period of Heva, or to use a Palestinian example, its Nakba, which is Arabic for catastrophe. We thus owe Keanu a debt for bringing this narrative to our attention, in that if it should succeed, it is the quickest and cleanest way back. Okay, here's the cons of this narrative. It is, in my view, unlikely to be seen by our international audience as fitting the facts. The Hawaiian monarchy lasted 78 years, half of which was already not as independent as we would have wished it to have been. Okay, I promise I wouldn't go into the reality since I know far less about it than the members of the audience. But in any event, the Hawaiian monarchy lasted some 78 years. US rule has lasted 111 to 116 years. That audience will likely ask, if the status ante quo, which means a status before US rule, is still, quote, normal, it is also likely to see, however wrongly, something more than a transient and hostile occupation in the US presence in Hawaii, something that it might call acquiescence, which is an international legal term, meaning that it might decide that the facts suggest to it that enough elements in the occupied territory have acquiesced to US rule, that the line between occupier and occupied has been blurred sufficiently that this is no longer a situation of occupation. Moreover, and this is an important point, a belligerent occupier in international law is understood to be at war with the occupied. While the overthrow relied on the armed might of the US, arguably annexation did not. The military motive behind the US presence in Hawaii at annexation and since has always been primarily directed at not the occupied, but at third parties, Spain, later the USSR, and now China. This is not Israel firing at Palestinians. And that is the archetypal example of occupation that the international community would be familiar with and would try and see whether it's analogous to the one in Hawaii. Finally, the international legal regime for deoccupation compared to those for decolonization and even indigenization is conspicuously underdeveloped in terms of available mechanisms and processes for redress. This is extremely important. There have not been enough cases of occupation, right, since the United Nations was created for there to be a huge body of law or mechanisms where you can bring your beef or processes. In other words, compared to decolonization, you have to almost invent the mechanisms and processes for redress. So this is another huge failing of this approach. No specialized committees, no fora, no tribunals for deoccupation to which Hawaii could easily bring its case. This partially explains, for example, why Israel's occupation of the West Bank has dragged on for half a century, and why the US occupations of Iraq and Afghanistan appear intractable. Now, of course, the Baltic states, formerly incorporated in the USSR, have been cited recently as examples of successful deoccupation. However, I would like to point out that the Estonian international law scholar, Lauri Malksoo, wrote in 2003 in a book appropriately called, I quote, Illegal Annexation and State Continuity, that the Baltic states, in their victorious case for independence from Russia, relied far more on the illegality of the USSR's annexation of their countries than on the argument that they must be deoccupied. Now, you know, for lay people who are not lawyers, you would think there's not a grain of difference between an illegal annexation and an occupation. But law does actually distinguish these things. So, and this is an option that is not part of what was put on the agenda. It's something that one should also look at. After all, the US has agreed, has already confessed that the annexation was illegal. I mean, that's half of your work done right there for you. The only thing is, okay, now how do we redress it? That's all. Whereas if you're trying to make a case that this is, you know, a situation of occupation, you have far more stumbling blocks to so convince an international audience.